Good afternoon, ladies and gentlemen. Good morning to those in the US. Welcome to Trinity Talks. Today we are talking about anti-bribery legislation, both in the UK and the US. Today's session will be presented by my partners Rinku Bedoria in London, who will talk about the UK Bribery Act, and my partner Tom Eldert, based in Washington, DC, who will talk about the FCPA. Without further ado, I will pass you straight on to Rinku, who will give an overview of what we're going to talk about today.
Thanks, Kaushik, and good afternoon to everyone attending. So today we are going to kick off with the key differences between the Bribery Act and the FCPA. I will then go into a little bit more detail on the key provisions of the Bribery Act, and Tom will do the same on the FCPA. So starting on some of the noteworthy differences. In terms of remit, the UK Bribery Act prohibits bribes to private individuals as well as public individuals, whereas the FCPA prohibits bribes to foreign governmental officials only. The treatment of receipt of bribes is quite different. The Bribery Act prohibits receipt of bribes, whereas the FCPA prohibits the payment of bribes and attempts to hide payments, but not the receipt of bribes. In terms of the corporate offence under both acts, under the Bribery Act, it is a strict liability offence for failure to prevent bribery for commercial organisations, and therefore there is no requirement to prove knowledge or intent, and that is subject to an adequate procedures defence. Under the FCPA, there is no strict liability offence. In terms of criminal penalties at the Bribery Act, you're looking at an unlimited fine and potentially for individuals, a prison sentence of up to 10 years. Under the FCPA, company fines can go up to $2 million per violation of the FCPA, and fines up to $250,000 on individuals per violation, as well as 5 years imprisonment. Facilitation payments are treated differently under both acts. Under the Bribery Act, they are considered to be a bribe, and we'll go into that in some more detail later on. Under the FCPA, there is a specific exemption for low-level facilitation payments, where payments are made which are lawful under the written law of the local country or reasonable and bona fide expenditures relating to a contract. So in the next slide, we will go through some of the offences under the Bribery Act. So there's three categories of offences. The first one is general offences, which is the giving of a bribe or receipt of a bribe. The second category is the FPO offence, which is bribing a foreign public official. And the third category is a corporate offence, which is where commercial organisations fail to prevent bribery. A note on the general and FPO offences from a commercial organisation perspective: for it to be convicted, there's quite a high standard. So prosecution needs to prove that a very senior person in the organisation, such as the CEO or MD, committed the offence. That's the directing mind test. So it is quite a difficult bar, and there has been recent case law where individuals in certain organisations have been acquitted for lack of evidence, including in recent cases such as Tesco's and Rolls-Royce. So most of our presentation really will be focused on the corporate offence. And a corporate offence is where a commercial organisation can be guilty if a person associated with the organisation bribes another person with the intention of obtaining or retaining business or advantage in the conduct of business for the organisation. As mentioned before, knowledge on the part of the organisation is not a requirement, and the offence can be committed in the UK or overseas. So the extraterritorial jurisdiction is something we will come on to later on. But what actually is a bribe? Broadly, it is someone giving a financial or other advantage to encourage that person to perform their functions or activities improperly, or to reward that person for having done so. This is a deliberately broad definition, and it goes beyond just the payment of money. So it may, for example, cover gifts, corporate hospitality, giving employment to public officials or their relatives, providing certain services or benefits, making political donations, or awarding a contract to a particular company. I think most of that is quite straightforward, but in terms of corporate hospitality on the next slide, there are a few grey areas, so we'll examine those a bit further. So in terms of corporate hospitality, we don't have any case law at present, but we do have some guidance from the Ministry of Justice that states that bona fide corporate hospitality, promotional or similar business expenditure, which seeks to improve the image of a commercial organisation to showcase its products or services or to establish cordial relations, is not caught by the Act. So in a pre-COVID world, providing tickets to sporting or music events, or taking clients to dinner, and offering gifts to clients even as a reflection of your good relations, if that is reasonable and proportionate to your business, would be fine. And I think if you're in doubt, the guiding principles to remember are, is there an intention to influence performance or decision making of a recipient? When was the gift or corporate hospitality made? So for example, was it before the award of a tender? Transparency, most companies will have a requirement to declare or document under company policy any gifts or services, and a level of self-awareness. So, is this a legitimate business activity, and the application of a reasonable man test. Facilitation payments are another feature of the Bribery Act, which do attract quite a lot of attention, and really, what we've gone through some of the detail on that, but again, there is no available case law on this. But firstly, what are facilitation payments? They are payments to induce officials to perform routine functions that they are otherwise obligated to perform. Businesses are encouraged to take action to ensure local countries are aware that these payments are unacceptable, and ensuring that agents and employees are given guidance on how to deal with requests for such payments, notwithstanding that such payments may be lawful under the local country's regulations. As I said, there's no available case law, but the guidance does confirm that the prosecutors will carefully consider all the facts and surrounding circumstances of cases to assess whether a prosecution is in the public interest. And what we do know from pre-Bribery Act case law, which clearly goes back over 10 years, prosecution tended to be for multiple payments rather than a one-off payment. So much has been made of the jurisdictional ambit of the Bribery Act. In terms of the general offences and the FPO offence, clearly if the bribery takes place in the UK, then any individual or body corporate can be prosecuted irrespective of whether they have a connection with the UK. Prosecution can also take place overseas if the act or omission in question would have amounted to an offence if it had occurred within the UK, and the person who committed the offence has a close connection with the UK. So for example, if they're a British citizen or ordinarily resident in the UK, or a body is incorporated under the laws of any part of the UK. Next slide, please. In terms of the corporate offence, this has significant overseas reach, and it is due to mainly the fact that it relates to failure to prevent bribery by an associated person. And therefore, it can be committed by UK companies and by non-UK companies which carry on a business or part of a business in any part of the UK, and the offence can take place within the UK or overseas. Unlike the general offences for the corporate offence, there is not required to be a close connection with the UK for the underlying offence of bribery. And therefore, an organisation can be liable by an associated person who is neither a UK national, nor resident, nor a body incorporated in the UK. And It may not matter that the acts or omissions which form part of the offence take part in the UK or elsewhere. In the next slide, we'll examine what is an associated person a bit more closely. So associated person is defined widely to include people who perform services for or on behalf of the organisation, regardless of their capacity. So this can include, rather obviously, employees, agents, contractors, unlikely to include subcontractors because of the sort of contractual nexus. And it can also include subsidiaries and group companies. And this was showcased in a recent Standard Bank case where Standard Bank in London, together with its sister entity in Tanzania, bid jointly for a private placement mandate in Tanzania. And although it was the Tanzanian entity that committed the offence, the investigation took place for Standard Bank itself. So clearly there was an intention to benefit Standard Bank in London, and that was the subject of the investigation. Joint venture partners can also be defined as associated persons, depending on the level of control and the benefits that are being provided. And finally, rather obviously, individuals or public companies providing the service will also be caught. So in terms of penalties, as mentioned before, if for an individual or for general offences or bribing an FPO, you're looking at a 10-year imprisonment or unlimited fine or both. And for any other person, such as a body corporate, or bribing for a general offence or bribing an FPO, is an unlimited fine. Corporate offences, organisations will be liable to an unlimited fine, and we've seen some pretty hefty fines in recent cases, which I will come on to in the next couple of slides. There are other consequences that companies should be aware of, not least reputational, but also disqualification of directors, trade sanctions, and potentially debarment under the Public Procurement EU directive, which would prevent that organisation from continuing to tender for public sector work. On the next slide, please. So adequate procedures is a defence to the corporate offence. It is the only defence. And unfortunately, there is no set checklist of what comprises adequate procedures, but the Ministry of Justice guidance has 6 principles which companies should take note of. So proportionate procedures. So these procedures should be proportionate to the bribery risks faced by the organisation and nature, scale and complexity of its activities. Top level commitment, so senior management commitment has to take place with oversight over the programme. So there was a case Skansen where it was quite a small company and adequate procedures defence was tested in that case, but they were prosecuted eventually, but what was found was that the senior management did not have the commitment and did not communicate anti-bribery policy sufficiently. Risk assessment, so periodic, informed and documented assessments of internal and external exposure to bribery, and due diligence is quite important to make sure that appropriate checks are carried out on service providers before services are actually engaged. Communications, this goes to the point I was making, training is important, and bribery prevention policies should be communicated regularly, internally and externally, and that training has to be continuous, so updates to that training as and when necessary. Monitoring and review, risk and procedures should be regularly monitored and reviewed to ensure compliance. So it's worth just noting the importance of self-reporting and cooperation. So the SFO, as the primary prosecutor and investigator of offences under the Bribery Act, will consider an organisation's decision to self-report as a relevant factor in deciding whether to prosecute. And we have seen around 7 deferred prosecution agreements under the Bribery Act to date. And these agreements really allow the suspension of prosecution until certain conditions are met, and in many cases fines have been paid. However, the DPAs that have been agreed to date suggest that a company will only be rewarding for self-reporting if it genuinely cooperates with the SFO. So, for example, in the Standard Bank case, there was a deferred prosecution agreement secured, albeit with a $25 million US fine. But in the Sweet Group case, for example, although there was self-reporting taking place, the level of cooperation was found wanting. So evidence was withheld for certain periods, and the SFO did not consider that there was a genuine cooperation with the SFO. So in that case, the Sweet Group were prosecuted. What are the advantages of self-reporting? It does manage the reputational damage. It gives you an opportunity for a negotiated settlement, and it avoids the mandatory debarment provisions that we spoke about earlier. I mean, it's just worth mentioning that in sort of a Rolls-Royce case, for example, the self-reporting was looked upon very favourably, but it did cost Rolls-Royce upwards of $100 million US to actually put that self-reporting, put those procedures in place. So, you know, it is not a step that you particularly want to go down, and so therefore the adequate procedures is the best step to take forward. I'll now hand you over to Tom, who will take us through the FCPA.
Thanks for that, Rinku. Yes, I will pass you to Tom right now.
Great, thank you, Kaushik and Rinku. So this section of the talk is about the Foreign Corrupt Practices Act from the United States. As an overview, the principal aims of the FCPA are really 2 elements. First is anti-bribery provisions, which is the criminalization of the bribery of foreign officials. And the second element is company record and internal control provisions, which are basically record keeping and internal control requirements that really apply mainly to companies listed on the US stock exchanges. For purposes of this presentation and given time, we'll just focus on the first one, on the anti-bribery provisions. As we'll note below, non-US companies may be subject to FCPA provisions. It doesn't just apply to US persons. Violations of the anti-bribery provisions can result in, for businesses, fines of up to $2 million or 2 times pecuniary gain or loss per violation. And for individuals, imprisonment up to 5 years and fines of up to $250,000, again, per violation. And it's worth noting the per violation component to both of those because they can pile up pretty quickly in instances where there's widespread bribery. There's plenty of cases where the actual penalties have been in the hundreds and close to $1 billion given multiple violations. Finally, as with the UK, violations can result in the suspension or debarment from doing business with the US government. We won't get into details because it's very similar to what Rinku covered with respect to the UK, but cooperation and having systems in place to report violations definitely can have a mitigating impact on what the ultimate penalty is of a violation. Finally, it's worth noting that a violation of the FCPA also has a significant reputation impact, even if you get a minor fine. If you're an international company, it's may well make the headlines, and that carries its own costs. Finally, I'll just note quickly that there has been a trend over really the last couple of decades of an increasing application of the FCPA to foreign entities, to non-US entities. And the reason for that largely is that US companies, since 1977, when the FCPA was put into place, have complained that US companies are at an unfair competitive disadvantage when operating overseas because foreign companies aren't bound by the same anti-corruption rules. And so as a result, the Department of Justice and the Securities and Exchange Commission have aggressively interpreted the FCPA to go after foreign entities, as we'll see in a minute. Next slide. So the anti-bribery offense is the payment of any thing of value to an individual, knowing that it will be paid to a foreign official in order to corruptly influence the official in some official act or secure any improper advantage in an attempt to obtain or retain business. So the key elements are, first, payment of any thing of value, and that's quite literal. The DOJ and the SEC interpret it very broadly, so a suitcase of cash is obviously a thing of value, but so is a bouquet of flowers for purposes of this test. Knowledge, this basically gets to intent. If you leave your wallet behind in a government official's office, that isn't necessarily going to trigger a violation. Foreign official, this is, again, very broadly interpreted by the DOJ and the SEC. It includes any government employee, which is obvious. It also includes members of political parties, candidates for political offices, and notably, and this is the area where it gets sometimes tricky, is any employee of a state-owned enterprise. Basically, any entity that is majority owned by a government or controlled by a government. So if you're dealing with countries where many, like China, where many of the companies have a state ownership element, even a secretary could, in theory, be considered a foreign official for purposes of the FCPA. And then finally, the payment has to be made for purposes of a corrupt influence on an official act or securing an improper business advantage. Finally, unlike the UK, so-called grease payments are not violations. For purposes of the FCPA, what this means is while you cannot, if you're applying for a operating license in a country, for example, you cannot pay a bribe to obtain and get approval of the license. However, if the local official comes to you and says, yes, this is approved, but well, COVID hit and we're short-staffed and it's going to take 2 months. But for $50, we could get it to you in 2 weeks. That technically would not be a violation of the FCPA. With that said, you have to be very careful with respect to grease payments for 2 main reasons. One, it's a pretty thin line between what is just facilitating the time and what is actually facilitating the outcome. And the DOJ and the SEC may not see it the same way you do. And the second reason is because, as Rinku noted, such payments may be illegal under UK laws or other corruption laws that may be applicable to your company. So who is covered by the Foreign Corrupt Practices Act? Basically, there's 4 categories: domestic concerns, issuers, officers, directors, employees, and agents, and persons who violate the FCPA in the territory of the US. So domestic concerns are pretty much the easy one. It's any business organized in the US, any business with its principal place of business in the US, and any individual who is a citizen, national, or resident of the United States. Issuers, broadly speaking, are companies that are listed on US stock exchanges. It can include certain companies who have foreign shares listed through bank certificates on ADR exchanges, but that's not worth getting into on this talk. Next, officers, directors, employees, agents, and stockholders of a covered entity, so a domestic concern or an issuer. Most of those are pretty obvious, except that it's worth noting that the DOJ and SEC interpret agent extremely broadly. Many of the cases use an agency concept to rope in, for example, foreign joint venture partners of US companies. And then finally, any person who commits a violation in the territory of the United States. This can be physical presence. There's actually a somewhat interesting case where a foreign national was traveling through the US, I think in Chicago, and had a layover. And while he was in Chicago, he sent some emails that facilitated the bribe of a foreign official outside the U.S. He then went to get on the plane and later was arrested in the U.S. So his only nexus was the fact that he committed or facilitated the bribe while he was physically present in Chicago. Next is the use of means or instrumentality of interstate commerce. This, particularly over time, has been aggressively expanded by the SEC and the DOJ. The courts sometimes push back on it, but they will expand it as much as they can. And this can include using telephone and electronic communications, email, either to, from, or via the U.S. if it's routed through a U.S. server, arguably. And then the other big one is use of the U.S. banking system. So if your basic rule of thumb is if you're dealing with U.S. dollars, there's a decent chance that you could be subject to the FCPA with respect to the bribery payments. And this includes causing a violation. So it's not just that, as in the case of the man in Chicago, it's not just that you paid the bribe while in the U.S. You can also tell somebody to pay the bribe. If you happen to be in the U.S., then you'd be in violation. Next is application to non-U.S. entities. So as mentioned, there's been, particularly since the mid-2000s, there's been a big uptick in investigations and pursuit of cases against non-U.S. entities. And the application really falls into 5 different categories. There's foreign issuers, territorial jurisdiction, agent of a covered entity, aiding and abetting and conspiracy, and U.S. employees. So foreign issuers, that one's fairly straightforward. As mentioned, it's basically foreign entities that are listed on U.S. stock exchanges. It's worth noting, just because some companies have claimed ignorance of this, it's not for bribes paid within the U.S., it's for bribes paid outside the U.S. So, for example, Siemens had a judgment against it for bribes that it was paying in a number of countries outside the U.S. from its German offices. Its only nexus to the U.S. was the fact that it was listed on the New York Stock Exchange. Territorial jurisdiction, this applies only if the non-U.S. entity makes use of the mails or any means or instrumentality of interstate commerce in furtherance of an illicit payment. This is very broadly interpreted. As mentioned before, it can be mail, fax, email, use of the banking system, basically any angle where the DOJ or SEC can find a nexus to the U.S., they may well try to take. So agent of a covered entity is the next one, and this is where it gets a little more nuanced and tricky, but is also a pretty common situation for cases brought by the DOJ. And this involves any entity that is acting as an agent for a covered entity. So if you're, the easy cases are, for example, if you have your independent engineer, of a U.S. company go out and pay a bribe, then he's acting as an agent, and that's obviously a violation. Where it gets more tricky is the broad consideration of what is an agent that the DOJ and SEC take. And again, as mentioned earlier, this often involves joint venture partners. So, for example, there was a case where there was a joint venture between a Texas company and 2 Japanese companies. One of the Japanese companies was paying bribes for a project in a foreign country. The Texas company wasn't directly involved in the bribe. However, both the Texas company, because it was a domestic concern, and the Japanese company, because it was deemed an agent of the Texas company, were found in violation of the FCPA. Foreign subsidiaries of a covered entity may also be deemed agent of the parent. So the 2 main circumstances for that are participation by the parent company in the illicit payments. That's fairly obvious. It's basically if both the parent company and the subsidiary are making the bribes, they're both guilty. The second aspect is where the subsidiary makes the bribe, but the parent company knows about it, whether directly authorizing the actions, via shareholders or otherwise, or even in some cases by approving the budget that allocates for the bribe. Next. Aiding, abetting, and conspiracy. Again, similar to the above, a foreign entity may be liable for conspiring to violate the FCPA or aiding and abetting a violation by a covered entity. So if you assist a U.S. company in making a bribe, you could be found guilty as well. Although it should be noted that this, while pursued by the DOJ and the SEC, has been pushed back by certain courts as too broad. And finally, it's worth noting that foreign companies, if you have U.S. persons, particularly officers, directors, or employees involved in the business that would relate to the payment of the bribe, they are personally liable for participation in a violation of the FCPA, even if the foreign entity making the illicit payment is not. So if you're a foreign company and you're making a bribe that's not a violation of the FCPA, but you have a director who's a U.S. citizen, the company may be completely fine. The U.S. citizen may get 5 years in jail. Next. Back to you, Kaushik.
Thanks, Tom, and thanks, Rinku, for that. Very, very helpful and a really useful talk through of some of the key points for the UK and the US bribery acts in the FCPA. Just having a look at some of the questions that have come in, and in the next kind of 10 minutes or so, I thought I could ask some of those to you. So, first one is really a practical question in terms of how does this all relate to documentation? So when you are negotiating either project documents or finance documents, where do the Bribery Act provisions come up and how are they dealt with? Rinku, if you don't mind, I'll turn to you first from kind of an English law docs perspective, and then we can turn to Tom. Sorry, Rinku, I think, yeah, I think now you are unmuted, sorry.
No problem, thanks for that question. I think in terms of documentation, if we look at finance documents, for example, particularly for development finance institutions, there are usually specific schedules on compliance and sanctions. So normally Bribery Act from a UK perspective is rolled into those sorts of schedules whereby there are certain reps, covenants, and also in many cases an event of default that points to compliance with bribery legislation, not just in the UK but also in the local jurisdiction as well. In terms of the sort of project documents or SPAs, this normally comes up in the sort of representations and warranties section. So again, entities are required to ensure compliance with those laws. I don't know if Tom's got sort of other views on how else they are covered.
It would be worth asking Tom, actually, if I can, whether there's any kind of ability to negotiate those clauses as part of your answer.
Yeah, sure. And thank you. No, I agree with everything Rinku said. I think, and there's really not a difference between the US and the UK. For lenders, there's really not much room to negotiate their clauses for two reasons. One, I mean, ultimately this is a risk allocation in a transaction, and the lenders aren't going to want to take that risk. So that's the business reason. As a practical level too, particularly in DFIs, but even for commercial banks, those are considered the policy kind of untouchable provisions. So a deal team would actually have to go back to the policy people or go to somebody higher up in seniority to approve changes, which they would prefer not to do. I mean, they can if there's a really good reason for it, but they prefer not to. In other contexts, and particularly M&A, I think you might have more room to negotiate a little bit. And particularly, I think the two areas to look at are, and one you should look at anyway, just so you know what the scope of your obligations are, but is the how broad the provision applies, particularly with respect to affiliates. Is it, just you and your parent company, just you and your shareholders, or if you're a large company, is it including completely unrelated projects halfway around the world that shouldn't have any impact on the deal? And if it's the latter, that's something you could probably find room to negotiate. The second, which probably is mostly only relevant in an M&A context where there's a little bit more flexibility to allocate risk, is adding some sort of knowledge qualifier, particularly if you're a small company, and saying, to your knowledge, you're not, in violation of the FCPA, but you're a company in a small country somewhere else and you don't have an FCPA lawyer. So, I mean, that's something you can try. But again, not with the banks.
Thank you for that, Tom. That's helpful. I mean, I guess you're sort of touching on another point, and we have a question about it. This is really about trends, particularly in relation to the application to either the UK or the US bribery acts that are applicable to companies that are outside of the US and the UK. And is there any kind of, if you're a company, for example, a South African company, what steps do you need to be taking, and is there any kind of commonality of approach that you can take? Rinko, I might turn to you first to answer that.
Sure. So from a UK Bribery Act perspective, obviously we've gone through the extraterritorial nature of the legislation, and therefore the adequate procedures is really the best mitigating sort of features that you can put in place in your company. So compliance programs and all of those sort of principles that we went through. I think in terms of collaboration, it's between this kind of different jurisdictions. I mean, we're definitely seeing a trend of the SFO collaborating with the equivalent agencies in other jurisdictions. So for the recent Airbus case, for example, the investigation took place both in London, but also in France as well as in the States. So there was collaboration between each of the agencies there. In fact, the SFO actually has secondees in from Singapore and equivalent agencies there. So, it's definitely trending towards much more of an international effort.
Great, thank you. I'll just turn to Tom.
Yeah, no, I completely agree with that, particularly the multinational effort piece of it. I mean, I think it's worth noting just very briefly the history of the FCPA, which started in 1977. And in the beginning, U.S. companies felt, as I mentioned earlier, that they're at a competitive disadvantage because nobody else in the world was doing this. In fact, in Germany, I think it tends to be a little exaggerated, the actual impact, but in Germany, it was legal to deduct bribes from your taxes until 1999. So, in addition to going after foreign companies under the FCPA, the U.S. was constantly pushing to get more countries to adopt and actually enforce anti-corruption laws. There's the OECD Convention of Combating Bribery of Foreign Public Officials that was entered into in 1999 and seems to be taking root now. And as Rinko mentioned, there's been an increasing number of multinational cooperation on cases. But I mean, I think the one statistic that's interesting is from 1977 to 2016, the U.S. accounted for 70% of all bribery prosecutions of foreign officials. In 2016 and 2017, that dropped to 23%, which was showing not a decrease in U.S. prosecutions, but an increase in prosecutions, particularly from Europe.
Thanks for that, Tom. That is an interesting interesting statistic and an interesting trend. Final question, I'm just going to stick with you actually, if that's all right, Tom, is what impact will the upcoming US presidential and other elections, House elections coming up, what impact will they have, or are they likely to have, on the FCPA or its application?
Sure. The interesting thing is, I think this is one area where it's not going to matter all that much. You know, historically, under both Republican and Democratic administrations, we've seen the same trend of increasing enforcement, particularly against foreign entities. There was some concerns from anti-corruption people in 2016 because Trump had been on record in the past as a businessman, not when he was campaigning, as saying the FCPA was a joke and it was hurting American companies. So I think if there was going to be any weakening of the FCPA, it would have happened between 2016 and 2018 when we had Republicans in all three instruments of government. Now I think with the Democrats, if they take power, you know, they'll at least still have the House. So I think it's just going to be status quo. And it's interesting because it's definitely one area where I think both liberals and conservatives agree, but for totally different reasons. So for liberals, it's basically a human rights issue. I mean, corruption's a problem. It clearly impacts development and increases poverty. So they, you know, support the FCPA for that reason. And I think on the Republican side, they support aggressive enforcement against foreign entities, basically to preserve business interests.
That is a good point and an interesting one. Thank you everyone watching. Thank you, Rinku. Thank you, Tom, for your very informative and thoughtful and thought-provoking talk, Trinity Talk today, on all aspects of Bribery Act in the UK and the FCPA in the US. This talk will be available on YouTube. You might be watching it on YouTube right now. But those watching live, please feel free to pass this on to your colleagues. We're taking a pause on the weekly Trinity Talks from now. We'll be sending out via our distribution list a revised schedule. We're moving to monthly talks, but we're always open to topics that may be of interest to you. So if you do have them, please feel free to drop any one of your Trinity contacts a line. But for now, thanks very much for watching. Thank you again, Rinku and Tom, and have a great rest of the day, everybody. Thanks. Bye-bye.